All right, ladies and gentlemen, this is the Juvenile Justice Committee, and we're going to call this meeting to order. Where the bills? Where's the bills? And we have a couple bills on the agenda today. We have House Bill 914, which is by David Wilkerson, and also House Bill 1053, LC 295712ER. And I'm going to call, and that bill is being carried by Ms. Chandler. And Ms. Chandler, if you're ready, I'll let you just speak from your seat there. Just kind of introduce the bill, and then we have some folks here to speak to the bill, I believe, Mr. Adams, and anybody else here to speak to the bill? Okay. Okay. Did you guys? All right. Put them on there, will you? All right, Ms. Chandler, want to go ahead? Let me get you on there. There we go.
Thank you. House Bill 1053 reduces the regulations for nonprofit charitable organizations which serve children who have run away or who have a history of running away or who are subject or at risk of getting in trouble with juvenile justice or child welfare, or children who have been placed in a particular organization that we're referring to by their parents or a guardian. And also, we're talking about organizations that receive more than 75% of their funding by individuals and communities and who have no state contract to serve children. And, Mr. Chairman, that is the bill. We're just trying to reduce some of the regulations that these organizations have to confront every day.
All right. Thank you, ma'am. Any questions for the presenter? All right. Mr. Adams?
I will tell you.
Okay. Mr. Thompson? That'd be fine. That'd be fine. Mr. Thompson.
Chairman of the Eagle Ranch Board. Today I'm just here to speak on behalf of Ms. Chandler's bill. What we want to accomplish is to help y'all understand that there are unique child serving agencies across the state of Georgia. They take no state funds and deserve a little bit of a different regulatory regime than they currently operate under today. As this narrowly drafted bill operates, we think there are only a couple of child care serving agencies, Eagle Ranch, the Chick-fil-A homes, Camp Windshape, and possibly Covenant House that will fall under this. And I'm going to defer to Eddie Staub, who is the founder of Eagle Ranch, has been the executive director for almost 30 years, to describe his agency. And then Mr. Norman Adams, that has been in the child care serving business for over 30 years, is kind of our subject matter expert.
Okay, great. Thank you. Gosh, when you say I served 30 years, it made me feel old. I'm representing also Tyra Walker, who oversees the Windshape homes for Chick-fil-A. And the common denominator between the Windshape homes and Eagle Ranch is that we take children from private sources. We don't take children from DFACS. Just to give you a little background about Eagle Ranch, is we began in 1985. And I was a founder and been the executive director since we take care of over 60 children, 42 boys, 22 girls, and a lot of sibling groups come to us. The thing that's different about Eagle Ranch, and I guess Chick-fil-A homes as well, is that we work with the families of the children. We feel like the family's, God's idea. And anything we can do to keep that family together, it's a good thing. So about 50% of our children are being raised by single moms, about 20% by grandparents. We've had some children being raised by great-grandparents, single dads, aunts, uncles. But our goal is to reunify those children back home. The average stay of a child is about 2 years. We take children from age 6 to 16. And some of them, of course, grow up past that. We have a SACS-accredited school for grades 6 through 9. So our little children go to the public elementary, our older kids go to the public high school. But we felt like that middle school is sort of our wheelhouse, is when you can best remediate children, sort of catch them so they can get through high school. We have 7 children living at home with a house-parent couple. We have 10 homes, and we have 6 licensed counselors, individuals, groups, and family counselors. And they work with the families to sort of correct generational breakdowns and sort of that these generational curses, whatever you want to call them, won't be passed to the next generation. And it's interesting, I had a mom say to me, which I thought was just pretty humbling for her to say, but she said, I finally came to realize that my son was the way he is because I'm the way I am. And so and for a child to see a parent own that and sort of join in, it's just a really powerful thing that we don't want our family to go on this way. So that's who we are. We're debt-free. Our budget's over $3.5 million. 80% of our operational budget goes directly to the children's program. So we're very low administrative costs. It's completely private funded. And basically, I'll answer any questions you have about Eagle Ranch, but Representative Oliver has been, hoping she would be here today, but she's been out to the ranch, and Representative Chandler's been out there. But basically what this bill would do, it would expand the Runaway Youth Safety Act that you approved 2 years ago, and it would allow for governmental oversight, which is more reflective and consistent with who we serve and how we serve. We serve kids that have been placed with us by their parents or whoever is left in the world. These aren't children from the state. We work with DFACs to get children before they go into the state. But we don't take DFAC children. These are just private placements. And in the oversight that we're currently getting from DFACs is inconsistent with, the children we take and how we serve. And we have, like I said, 6 licensed counselors with over 100 years of counseling experience. So that's what this is about. And Norma Adams will discuss
Mr. Chair, members of the committee, it's a pleasure to be here before you again, talking about child welfare issues. My name is Norman Adams, and like Kirby, I'm a volunteer advocating for this bill. Last year, I retired from the Georgia Association of Homes and Services for Children, which is a trade organization for group homes and foster care agencies across the state. We represent over 300 licensed programs statewide. I retired last year, and after 22 years of service there. But prior to that, I served 10 years at a place called Christian City, which was an agency that served nothing but children who were placed there by their parents or by their relatives. And it was a wonderful place to be and care for these kids because it was we WinShape and Eagle Ranch came to me, as other agencies that come to me, about something to reflect the nature of these community-based agencies. I thought it was a privilege to be able to help them advocate for that. And this is what House Bill 1053 is all about. It's empowering the community, but probably more important, it's empowering families to care for their kids. Let me give you a statistic. If you take away anything, take away this. If a family gets involved with the state welfare system, DFACS or juvenile justice, they're 3 times as likely to stay involved with those systems. And what we're saying is we want to work with the families before they get involved with the state. But we believe that it requires a different type of licensure and a different type of oversight. And so this is what House Bill 1053 attempts to create. Now, 2 years ago, Representative Tom Weldon introduced the Child Safety Act, which created a limited version of this bill, in the sense it created agencies that could serve homeless and runaway youth that served less than 6 kids. But that bill needed to be expanded to include only less than a handful, and we've only identified 2 additional agencies that this would impact to be licensed as community-based child welfare agencies. Now, what they would look like is they could serve more than 6 kids if these children were placed by their parents or by their guardians. Also, these agencies could not be what we call a governmental agency. They could not serve children that were placed by the government. They had to be serve children placed by the parents or guardians. They also had to get at least 75% of their funding from the community or through individuals or through the family. And so these agencies are nonprofit, therefore they're board directed, they have board oversight, and they have community oversight because of the funding that they receive, and they empower families to take care of their children. And so, and also an additional thing that this bill does, that is an expansion of the Child Safety Act, is it preserves the tax exempt status that these agencies presently have. So this is what this bill is trying to do, and we ask for your favorable support of this bill.
Okay, we have a question.
I hit my button wrong, Mr. Chairman.
Okay. How about you, Ms. Jones? That's not you? Okay.
That was me.
Okay. 24. All right. Representative?
I have a question for Mr. Thompson. Are the school facilities located in your campgrounds?
Yes, ma'am, they are.
Okay, and they're all certified, but you talked about SACS accredited. Okay, thank you.
All right. Let's see who else we got here. Representative? Who's that? Okay. Go right ahead. Representative Bell.
Thank you, Mr. Chair. I'm not sure who to address this to, but if you could lay out for me just the bottom line, what oversight are we trying to change in this? Like what exists now and how will it look if this bill passes?
Well, under the Child Youth Safety Act, which was passed 2 years ago, it required that these agencies demonstrate several things to the Department of Human Services, which has the licensing on for child welfare agencies. What they have to demonstrate is that they have policies and procedures that demonstrate they can adequately care for the children. They must demonstrate that they have qualified staff to care for these kids. It requires certain things of those staff to make sure that they have background checks. It also allows Department of Human Services to come into the facility if there is a complaint or somehow they become aware that there's a deficiency in those standards. Okay. So it's the same as the Youth Safety Act. that would be applied to these agencies as well.
Any other questions?
I do have one more.
Go right. I think you're still on.
And as a follow-up, is there anything that these particular facilities now have to do that they will no longer have to do once this bill passes?
Yeah, one thing that these facilities will not have to do if this is passed is presently DFACS or the Department of Human Services can come into these facilities
Okay.
at any time.
At any time,
And that's,
okay.
that provision has been changed so they only can come in if there's a complaint or knowledge of deficiency.
Go ahead, Representative Bell.
And if we remove this particular type of oversight, does that mean then that the facility is now responsible for policing itself?
Absolutely not.
Okay.
No, absolutely not. These facilities, they have oversight.
Okay.
One thing, they are non-profit corporations, which means they have to have the community-based board to provide oversight.
Okay.
They provide oversight. The community gives 75% of the funding,
Right.
at least. That's, the community demands oversight.
Okay.
And also, too, the fact that, that DFACS can come in upon the knowledge or or a complaint means that they will have oversight, too. So,
as well. Okay.
no, they will not be policing themselves. Matter of fact, we welcome that kind of oversight, but we don't welcome intrusive oversight that has a cookie-cutter effect on these agencies that are trying to provide family-centered, child-centered services to their communities.
Okay.
And that's what the present regulation does. It's cookie-cutter, and every agency looks the same because the state is funding most of these agencies. These agencies aren't funded by the state. They're funded by the community.
Okay. Thank you, sir.
Thank you. Yes, ma'am. The chair has a question. There's been some discussion regarding some other modifications to the bill that's recognized as LC 295712ER. And you have, I think you have a copy of what we're looking at, the committee's looking at today, right?
Yes.
Okay. Now, what's been presented in that LC number, the category that the thing that I see that identifies a category of homes that are being identified in this new potential legislation is in 25 and 26. It'll require that the entities you're referring to receive 75% or more of its, actually more than 75% of the funding from a source other than the state, actually being community or individuals that do not contract, and the entity will not contract with the state. And that's the case for Eagle Ranch, that's the case for Chick-fil-A Homes. And what about Covenant House?
And also Covenant House.
Okay.
And there's also 5 other registered agencies in the state that are that serve presently now 6 or less children.
Okay. Okay. Now, what about the other agencies that fall under this category of organization? All the other ones will still have to be subject to inspection by DHS, DFACS, just like they are now. And the reason for that is because they contract with the state or they receive less than 75% of their funding from the community or individuals. One of my concerns about the use of the word community, there could be that I'm not sure it excludes or includes corporations that are located closely around that the area where the Eagle Ranch or the Chick-fil-A Homes are located, or they could be out of state. And I don't want preclude that funding from out of state. Let's say New York Life wanted to, provide some funding for Chick-fil-A or Eagle Ranch or other entities that will fall into this category. Is that language something you're comfortable with?
We are comfortable with that language of community because, I mean, corporations, I mean, like let's take the Walmart Corporation. I mean, they're part of the community. They give to these community-based agencies because they have usually a Walmart in the community, and so those are how the grants work. So we're fine with that.
Okay, all right. The other provision or provisions that are in this new legislation. This would allow these entities basically to do everything that is provided in the Runaway Youth Protection Act, in addition to, and it just pulls out some of the requirements for inspection. Is that?
Yes.
That's what you got here. Okay. And are you comfortable with the language that's inserted here? We had talked about some other language about creating a different category.
Yes.
And I think I have that.
Yeah. One of the things that we do have difficulty with in the code section, there's various references to what they call child welfare agencies, and in order for these agencies to continue with the tax exemption, they would have to be included in the definition of a child welfare agency that's found in other sections of the code.
Okay. Representative Dickerson.
Thank you, Mr. Chairman. I wanted some clarification just to, for my own purposes. I have an organization in my community called Phoenix Pass. Are you familiar with Phoenix Pass? Haven House. And it serves homeless youth as well, but they also serve families. Would an organization such as that be protected under this new bill that you have proposed here?
Do they provide 24-hour care?
They do, and they get their monies from, like you said, community and individuals. Being one community partner would be United Way. Do you get monies from United Way as well?
Okay. Do they contract with the state for any kind of out-of-home service?
No.
They would most likely be included in this bill.
Okay. All right. Thank you.
Thank you, Representative Dixon. Any other questions? Any other comment?
Mr. Chairman, if I could just summarize, I think what we're trying to accomplish is empowering families and empowering communities to look after children. As Norma said, he ran a state agency, a state nonprofit, and he saw probably over 200 youth organizations fail in the state of Georgia. Those are ones that contracted with the state. And what we're trying to do is empower and create more communities and families to create a place where their children can go, and they'll be ruled on by the community and not by the state. So when private funds are invested, corporations like SunTrust, my personal donations, we have people who will be a steward of that agency, that organization, like Mr. Cathy's done at Chick-fil-A, like Eddie Staub's board has done at Eagle Ranch. And that's really what we're trying to create, because the state has really got a different kind of regime. We want to create something to foster less regulation and more growth of community-based child welfare agencies.
Okay. Hold on just a second. Representative Welch.
Thank you, Mr. Chairman. Does anyone know if this legislation doesn't do it, but is there rulemaking authority so that some of these terms can be better defined in rule? I mean, we have some are homeless. Well, I mean, a lot of children have homes that just had chosen to run away from that home. And I'm not trying to make light of it. I'm just saying that the words could be by a lawyer such as myself. They could be construed in many different ways, and that could have the effect of the Revenue Department construing them unfavorably. So that was my concern, and I just wanted to make sure that if we have rulemaking authority, then we try to exercise that in the process. If we don't, then we may need to look at these words more carefully.
Yeah, there's two sections of the code that allows the Department of Human Services to have rulemaking authority. One is presently under the Youth Runaway Safety Act that was passed 2 years ago. It gives them authority to develop rules and regulations, which they already have done, and they usually do that in consultation with providers out there, and they did that last time. And there's also rulemaking authority for a licensure section for child welfare agencies. So that, yes, they do have. To answer your question, yes, they have rulemaking authority. And
it sounded like the rulemaking authority was limited and focused on particular activities or particular code provisions. What about with respect to this particular title and chapter?
Yes.
Would that be covered as well?
That would be
okay.
covered. Yes.
That's all. Thank you.
Okay. Thanks, sir. Any further questions? Seeing none, we'll close off discussion from the public, input from the public, and the rules on the rest of the committee.
Motion to pass.
Here's a second. Motion do pass, and there's a second. All those in favor, well, is there any discussion on the bill before we get to the vote? Seeing none, Chair calls the question. All those in favor of the motion do pass, signify by saying aye. Aye. All those opposed, no. Unanimous. Thank you.
Thank you.
Yeah, we're going to have to look at some of that stuff. That's all right. I just not got it.
Questions? Yeah, three.
Okay, we have also, where is he? I don't see him. There's Representative Wilkerson.
Yep. Chair
recognizes Representative Wilkerson to present House Bill 914. That's LC 371748S. Let's see, which number are you? 1112.
12.
Gotcha. Okay.
Thank you, Mr. Chairman. Members of the committee, today I present House Bill 914. This bill started with last year. I don't know if many of you were on the call, but there was a call regarding deaths that had happened with children going through that were involved in the DFAC system. And one of the questions that I had was, if the schools had seen suspected abuse, where did it fall through in the cracks? And as I did some research and started talking to counselors and talking to DFACs, I started to get a better understanding of the process. And so what this does is address what I think are two weaknesses in the system as they currently stand. The way it works right now, anybody who works with children is basically a mandatory reporter, meaning that if you suspect child abuse for any reason, you report it to DFACs once you have that suspicion. You have 24 hours to do that. And so it could be a volunteer coach. I coach soccer. It could be me. It could be someone in the school system. It could be, anybody working at their church. And what happens is once it's reported to DFACs, you may get a notice that says, okay, we got your report, and then that may be the end of what you actually hear as regarding the case. Focusing on our school counselors and our school personnel, because they deal with the children every day, I decided to try to strengthen that piece of it, because most likely your school personnel are going to be the ones that are reporting these cases. So in the one case where the child had passed, it had been reported in the school system, but that child ended up moving away. And if a counselor had gotten a report back saying that the abuse was unconfirmed, then that counselor would have known to escalate it. So what this does is, you read through it, is it would have two reporting requirements. One would be on lines 18 and 19. Once the agency receives a report indicating suspected abuse, they would have 24 hours to say, okay, we have your report, we're going to look into it. That's the first piece. The second part of the reporting would be lines 20, whereas once the case is confirmed or unconfirmed, then another letter would go back to the counselors or the school personnel and say the case is, just giving them an update on the status. And the reason we need that second piece of the reporting is because it closes the process. If a counselor reports suspected abuse and then they see that, or I'll give you an example. A teacher comes to a counselor and says, I suspect child abuse. The counselor reports it to DFACS. DFACS doesn't necessarily get back to them. The teacher comes back to the counselor and says, what's the status of the case? And the counselor will say, I don't know what that status of the case is because I haven't heard back. What this does is it closes the loop and provides accountability for both DFACS as well as the counselor to say, okay, we know the status. If they come back and say that the case is closed and the counselor has any belief that it should be opened again, then they can go back and escalate it again. I've tried to answer a lot of your questions, and I appreciate all the tough questions everybody had on it. What we also wanted to do is make sure that we did not give any additional information than what is already required by law. So current law says that if the counselor requests this or the reporting person requests this information, they can be given that information. Unfortunately, it doesn't always happen, so this just kind of automates the process. I've talked to school counselors, and they are supportive of it. I've talked to DFACS. They are supportive of the bill the way it stands now. And so with that, I know we have some other people that are can give you real-life experience, talk about it, and would love to take any questions right now.
Okay. Let's see. Here's number 27. Representative Kendrick.
Thank you, Mr. Chair. I do have a question about line 18. It says that the agency shall respond. I don't know if you've thought about adding something that says in writing, just because you can respond verbally. Hopefully that strengthens what you're trying to get accomplished by the bill, is to create a trail whereby you know that you have sent the response. So I would prefer to have in writing added to it. And then my second question, or my first question, that was a comment, is line 21. It says whether the abuse was confirmed or unconfirmed. This is to confirm that the abuse did happen or didn't happen, or just to confirm that they received the report of abuse?
The second piece is actually pulled from current code, which is whether the child abuse was confirmed or unconfirmed. So it's relating to the actual abuse itself.
Sorry, that was me. Okay, you're going to have to say it again. Sorry.
Okay, yes, that's okay. On line 21, it says whether the abuse was confirmed or unconfirmed. And that pulls from current code. Basically, they already have access to that information. This just makes it automatic. So once the case is closed, it would let them know whether or not it's been confirmed or no child abuse was found or neglect.
Representative Welch.
Thank you, Mr. Chairman. Representative, the question I have is really dealing with, is it important as to whether or not, the language that I have trouble with is what Representative Kendrick also raised, whether the child abuse was confirmed or unconfirmed in lines 17 and 18. Mm-hmm. And I understand wanting a teacher or counselor wanting to know that an investigation has been done and been completed. It troubles me, even if it is under current law, that the additional information of whether the abuse was confirmed or not, to me that seems to go beyond the knowledge that someone should have. It's almost like we're sharing information that really should be between the parents and the children and the family, and then that one governmental official that's investigating the situation. Beyond that, it seems like we're actually revealing more information than we ought to, even if it is under current law. So that was a question as to why is that necessary, if it is still necessary, and we can always change the law now. Yeah. And then the second part of the question was, I like what you're trying to do in lines 18 through 21. However, the way it reads that the Department of Governmental Protective Agency shall respond to the person making the report within 24 hours of such report, advising that the report was received. And then so you have to both advise as to whether the report was received, and then you also have to advise that whether the abuse was confirmed or unconfirmed. So you have those two reporting mechanisms there. And it's a little confused the way it's worded, because it says that you making the report within 24 hours, and I'm not sure if the 24-hour rule applies to the. It's worded such that it seems that it applies to the to when the governmental agency has to report back. And is it the intention of the author so that the report back to the counselor will be done within 24 hours, or are you referring to the 24-hour report made by the counselor?
Actually, those are very good questions. The first piece, let me answer your second question first. The very first initial report, under current law, we have decided that once you suspect abuse, you have 24 hours to notify the agency of that abuse. If you don't, I do know that there are penalties, because in Cobb County, for example, we've had 2 principals be arrested and a counselor for not reporting within a 24-hour period. So this kind of closes that loop. They send it up in 24 hours. DFAC sends a notification back to them saying, we have the report. You're good within 24 hours. So it kind of closes that first loop that you've made your report. We have your report. We're looking into it. That gets them to where they know it's being handled right now, or at least someone in that agency's got it. The second piece of it is where you kind of bring it full circle, whereas DFAC has had time to do their investigation, and we actually talked about this. One of the requests would, and I'll talk about later, would be actually for the completion of the report to make that within 5 business days. But the reason that report is needed is because you may have an instance where the case has been unconfirmed by DFAC. DFAC says, you know what, we found no abuse here. Meanwhile, you have a teacher that's looking at a student that has the same clothes on for 3 days, comes to school hungry, or any number of situations. And once they find out that that case has been closed, they know it's time to get back on the phone and report it. The only other option that they currently have is to continue to report that case as many times as they do. And with DFAC's staffing, it would be better for them to allow them to do their work than to keep reporting it, because then you kind of clog up the system. And so it defeats the purpose there, I think.
And that's Mr. Chairman, just if I may continue, the concern is that you won't really know whether the investigation has resulted in a confirmation or unconfirmation of abuse, typically within 24 hours.
No, that's why I'm saying that, one of the wording changes we had was making the report within 24 hours of such report, advising that the report was received, and shall report to the person within 5 business days of the completion, advising whether the abuse was confirmed or not confirmed.
Okay.
So if we added that second piece in there as far as the time frame, the only reason it wasn't added in subcommittee is because I wanted to confirm with DFAC that they were fine with the 5 days, and they did confirm that they were okay with having a 5-day reporting period on the back end.
Okay. And Mr. Chairman, at the appropriate time, I have several amendments that I would like to propose to revise that language, I think, and hopefully provide some clarity to it. And so whenever that's appropriate time. And while that's being asked, and I'll just notify the Representative Wilkerson that what that is. If it is not material as to whether the child was abused, the confirmation of abuse, if that is not material, then I would suggest that we place a period after "if completed" on line 17 and strike the rest of that sentence. The other suggestion I would like to propose is that on line 18, where it says the Department or Governmental Child Protective Agency, and I would put "shall within 24 hours," insert "within 24 hours" between "shall" and "respond,"
And then after respond, insert in writing.
Can you repeat that?
So that it'll read, the department or governmental child protective agency shall, within 24 hours, respond in writing to, and then it reads on from line 19, the person making the report, and then strike within 24 hours of such report. And then, so the sentence will then read, the Department of Governmental Child Protective Agency shall, within 24 hours, respond in writing to the person making the report, advising that the report was received, and that would put a period there after the word received. Strike and shall report to the person, capitalize the word upon, and then it would read, upon the completion of the investigation, comma, the department or government, and this is an insertion after investigation, comma, the department or governmental child protective agency shall, within 5 days, of a determination that the investigation is complete, report. You with me?
I'm writing it, yeah. I'm now taking it in. I'm running out of space.
Report in writing within 5 days of determination that the investigation is complete. Report in writing to the person making the initial report that the investigation is complete.
Yeah.
So,
And that goes back to your concern about the confirmed or unconfirmed. Now, and I'll leave it up to the councilors, because my thought is that what that's going to require is that once they get the report, they're just going to automatically turn around and send a request in to get the information, whether it's been confirmed or unconfirmed. That's just a guess that I have, but they can speak to that, because if they're getting a report saying the investigation is complete, then I guess at that point, then they would have to initiate another request to DFACS to find out the status. Does that make sense?
yeah, and I guess the question is, that's a policy question as to whether or not teachers, counselors should have that information about whether an abuse occurred or didn't occur. And I'm not saying that I know the answer, but
Yeah.
it just seems like.
And current law says that anybody, so I mean, actually anybody, if you report it or I report it, current law says that we are entitled to that information upon completion. But like I said, my focus was on those that actually I think would have the expertise, because I'm reporting it because, one is required by law, and I may suspect it, but at the same time, I'm not, trained in that profession. But like I said, I would love to hear their thoughts on it. But thank you for those. These definitely helps clean up the wording. Yeah, DFACS is not here today. They were here in the subcommittee meeting. Oh, yes, they are. I'm sorry. Yes. Do you have any thoughts? Or do you want, I'll leave it to the chairman to see if he wants to.
I don't think we'll have a problem with the language clarification. I do know that the department supports this legislation and was appreciative of, and also picked up on the addition of the 5-day extension. Thought that would be very helpful.
Thank you. Thanks.
Representative Sharper. Check one. Thank you, Chairman. I'm listening to what I'm hearing. Everything, sounds good. But going back to Chairman Welch, your concern, but being a medical professional over 20 years and also working in the education system for about 20 years and dealing with, reporting abuse, and being that you have the teachers, and a lot of times it's the counselor in the school that even if the teacher reports it, everything kind of sometimes filters through the counselors, and they kind of work with the agencies. And what you see a lot of times is, even though it's reported, if they don't know if it's confirmed or what they see, then a lot of times it's a gauge of where, if I'm seeing certain things that I think is abuse, right? If I'm told at some point that, that case that you were talking about, it was confirmed abuse. But if I'm never aware of the things that I'm reporting,
if I keep on reporting things and nothing comes of it, then I'm going to have to look at myself. Or if I'm letting certain things get by, I'm like, well, maybe I should have, I don't know. You know, I think it kind of helps the people, even the council and some of the teachers, to know that we're doing the right thing. We're finding out it is being confirmed. We can now identify even times where we see a child may come and the teacher and the counselor, they're sitting there and the kid is talking to them about what's going on or the abuse or what, you know, what's happening. If they get back that this is confirmed, then it gives them more knowledge and understanding on what they need to report and not need to report. So, I mean, it's one of those things as a medical professional in the education system, it's good to know it's not we're going to go out and say, look, so-and-so is, you know, abusing their child, or this is going on. It's just that if he doesn't know and maybe they've closed it or haven't closed it, and you're looking at that same child, I'm wondering what's going on with it. Is it abuse still going on, or what the situation is? And it'll keep them from being, you know, out of balance of the child's situation. So that was just something, you know, that I was just thinking about on this. That it helps to know confirmed or unconfirmed, because you also have the safety and the privacy issues that the counselors are good at doing. So I don't think, and like you said, it's already the law that is open to it, but I think this will help because he did come with, you know, we're talking with school teachers, school administrators, school counselors, so that's holding them to a higher realm to keep the privacy in place. Thank you.
Thank you, Representative Sharper. Representative Dixon? Is that? Oh, excuse me. Representative Chandler.
Thank you, Mr. Chairman. In light of what you're saying, let me just piggyback a little bit on that. As a retired school counselor, I can say to you that this report would come back, I think that you have in mind, Representative, would come back to the person making the report. And that typically is the school counselor who recognizes confidentiality. And that counselor knows ethically that counselor then cannot go back to even the teacher that's made the referral and say, this child was found that he's been abused. So that information, Representative Welch, would not be given, I don't believe, to a teacher. And this information is needed. The counselor needs to have the information as to whether there has been abuse found or it has not been found, to know how to best work with a young person that's involved. It is just a safety net for our children.
Thank you, Representative Chandler. Representative Howard.
Thank you, Mr. Chair. And I would like to piggyback off of what Representative Chandler just said. What I think is, and I support the bill because what I think will happen is if you have a counselor that's typically the one that's reporting, and you have a case where abuse is continuously being reported over 1 year, and they see these kids from 1 year to the next, from one grade to the next, and God forbid that counselor reports and never know what's happening, or never knows or have any way of knowing what's happening, what happened, and not to say that they need to know details, that they say, well, it's no need in reporting, and don't report. And if they don't report and something drastic or tragically happens, I can't imagine what kind of impact that could have on that counselor or that person who's typically the one that makes the report and made a decision to not report when it was actually worse than everybody around her or he may have seen. And I think that safety net needs to be there. So I do, hopefully that we can move in a direction where we can give. And what was even more impressive, I think, Department of Human Services was in support of this bill, if I heard that correctly, in the subcommittee meeting that we sat through.
Thank you, Representative Howard. To the author of the bill, it seems to me that through your presentation and through the other comments that have been made, we've got information that needs to be that's required to be reported by mandatory reporters, and that's school personnel, teachers, counselors, and administrators. And when it also in the bill it says or other school personnel. Now, other school personnel could include the janitor. It could include people who are not there for purposes of providing an education or counseling to the children. And so I think we need to be circumspect in the way we approach this issue. It seems to me that there's consensus, at least, that if a mandatory reporter, that is a teacher, school administrator, school counselor, or other personnel, example be the nurse, or janitor, or somebody else that you may have some of the folks that are preparing the food for the children, they may be one of the other personnel and they report that. Now, I think it's important for a lot of reasons that the person reporting get confirmation that the department has received a report of suspected child abuse. And you know, if there's some folks that on the committee that like to address that issue, I certainly welcome your comments. Now, then in your bill, it also provides that starting on line at the middle of line 15, after the word "made," then there's a comma. Then the word, it reads as follows: which shall disclose only whether the investigation by the department or governmental child protection agency of the reported abuse is ongoing or completed. Now, then it, and if completed, then you start in, after that it says what I believe is a separate part that needs to be broken down in this subcategory. It says whether child abuse was confirmed or unconfirmed. Now, let's say if one of these school personnel folks that don't fall into the category of school teacher, administrator, school counselor, that information, I'm not sure, is the kind of information we want to be disseminated through those channels. One thing I think we need to seriously consider is I think it's necessary for a school counselor, in order to provide counseling to the children, they would need to know that information, if it's been confirmed or not. If it's been shown that it's, you know, the little boy fell out of a tree and his daddy wasn't beating the daylights out of him, then, you know, that's one thing. And daddy told him don't be in the tree anyway. So, you know, that's one thing. And they need to know that. It's not, they can't make if they make a report of suspected abuse and it's confirmed that it was not, or it's found out to be not abuse, then that needs to be reported, particularly to the counselor. So the counselor can say, yep, you did what your daddy said you shouldn't be doing in the first place, and you found the consequences of disobedience, didn't you? And Lord knows I heard that enough. But that's one of the things that need to be addressed with the counselor, and I'm not sure it needs to be disseminated otherwise. I really kind of feel strongly that it probably doesn't. So I think we need to make a special provision in here regarding the confirmation or the confirmation that there was no abuse involved. That needs to go to the counselor specifically. one of the issues we have to deal with, if one of these mandatory reporters, they have 24 hours in which to make a report of suspected child abuse. Now, it's a little bit onerous to have the department respond within 24 hours because the department may not have anything to report at that point. You know, it takes time to get that communicated to the department. It takes time to get that analyzed. It takes time to gather data. It takes time to find the child sometimes. And it's necessary it's necessary for someone to locate that child. Sometimes what happens is a child may be in a school and the child has been abused. The parent takes the child out of the school after they suspect it, or they just get wind, or they think that somebody may have reported abuse. They take them, move them to another school district. Well, the response back is necessary to that reporter that they received the notification of suspected child abuse, and the counselor can then, when they get the call back, they say, well, we can't find the child. Something needs to happen there. Just a second. And I see a few lights coming up now. So we need to be, we got to be circumspect how we come out of this and how we put this bill together. And I recognize Representative Sharper.
Okay, briefly, I think my understanding of the 24 hours is basically a confirmation that we got your complaint, which that's all that first 24 hours would do, is saying we got the complaint from you, so they don't have to go and find anybody and do anything else. It's just saying we got it, and so that they'll know that it was received by them. Quickly on an example, quickly on how this thing works. Most schools have some type of protocol. Even the janitor sees something and thinks there's abuse. The thing, most schools, he's gonna get that information to the counselor, and the counselor is gonna take it from there and follow up and check out with that child. Then they report it. Once it's reported, those 24 hours go by and they know it's good at that point. Once they get confirmed with this entire investigation, at that point, it'll go back to the counselor and say, this is what happened, and that's it, and it doesn't get back to the janitor because the buck stops with the counselor. So that's kind of the norm in most schools on protocol.
Okay. And again, we want to make sure in state law we include the counselor, and the way that the legislation is written, I think right now, we get the confirmation of that they received a report, and I think that's what you're advocating for. Whoever reports it, they get. Sometimes there may be a snow day, and they're in the middle of the day, and the counselor's already gone, and the janitor sees something happen, or sees something he or she suspected to be child abuse, and they report it to somebody else, and it kind of gets out of protocol. I want that to be addressed.
Mr. Chairman, may I add?
Hold on just a second. Yep.
Thank you, Mr. Chairman. And you should have the little sheet where it kind of highlights the information that's currently available. I know there's some concerns about what current law says they have availability for, but in most places, as Representative Sharper said, it is the counselor that reports it. However, that information can only flow back through the through the person who's doing the reporting. So if the janitor was the one that reported it, then the counselor could not come back later and ask for that information. It would have to flow through whoever that reporter was. Does that make sense?
Wait, I don't think I followed that. I had a few things going up here.
You're understanding, right? Yeah. Okay. Say in most situations, if there is a counselor, especially on the school, if I see something and I give it to the counselor reports it to DFACS. The counselor is that reporter, and the counselor is entitled to the information by law to get that feedback. Now, if it's a snow day or something happens and that janitor or custodian cannot find the counselor or decides to report that themselves, then they are now that contact person with DFACS. So the counselor could not come in later and ask for a status of the case necessarily and be required under the current law, because it says any adult who makes a report of suspected child abuse. Now, the counselors may have a relationship with DFACS, but the way the law is currently, is my understanding, that information flows only back through who that reporter is. And that's why we kind of pulled out just the school personnel because, like I said, I don't want to give it to anybody on the street. I just want the people that are dealing with it. And it will be, and I'm, the other personnel, like you said, could be a nurse or somebody like that. And I'm fine with that because they can always work their way through it. If that's the biggest, if that's causing a lot of heartburn for the chair, then I'm okay with, I think, the other school personnel, but I would have to, like I said, leave it up to the folks that deal with it on a daily basis.
Okay. All right. Representative Atwood.
Thank you, Mr. Chairman. I thought about this bill and reread it actually this morning after we dealt with it in committee, and I had three concerns in committee. One was it supported by the department, and does it improve efficiency as far as eliminating redundancy in reporting, and does it provide some checks and balances on defects as far as their ability to act in a timely manner. And upon reflection this morning, I had some concerns about line 14, which was or other school personnel, because I wanted to be able to be sure that it's a nice to know that I did it, that I reported it, but do we have a need to know to use this in our job? And I in turn was a little concerned about other school personnel. One thing I wanted to discuss with the chair and the other members of the committee is in line 14 the possibility of striking or other striking or other school personnel, quote unquote, and inserting or school nurse and or school resource officer. Those are the only ones at a school system, in addition to the administrator, teacher, and school counselor, that I could think would possibly have a use for this and would have a need to have it. If we made that change and then moved on later in subsequent years to determine there are others that are in need of it, we could certainly revisit that. Likewise, on line 19, I thought that this morning also, and I was concerned about the timeliness and the possibility of adding either 48 or 72 hours. I want that report to go back. We got it, because I don't want people sitting, personally, I don't want people sitting on information. I want them moving in a timely manner to deal with it. And this is another check for DFACS to, in fact, do that. So that's the thoughts on it.
Okay. Thank you. Representative Atwood. Representative Chandler.
I believe I'm correct in saying that every school in Georgia is required to have a child abuse reporting protocol. That protocol may or may not say that the counselor is the one in the building to make the report, but more than likely the counselor is the person. But that person, besides a school nurse, could also be a social worker, could also be a school psychologist, could be a resource officer. But I think every school system, every school has that protocol. And I think every school also has, if it is a school counselor and there's only one counselor in the building, in case the counselor is not present, then it would be made to someone else, if that would help any.
Thank you, Representative Chandler. Do we have comment, public comment? You have some witnesses here to testify, Mr. Wilkerson?
Yes, I do, sir.
All right, call them up.
Okay.
They on the list. Let's see. You know what? I got a list here. I might as well use it. How about Matthew Gamble?
Well, thank you, Mr. Chairman, members of the committee. I'm Matthew Gamble, and I have the opportunity to represent the Georgia School Counselors Association. We have been working with Representative Wilkerson on this bill for several weeks now and recognize this to be an issue, as I think most of you realize it is, and needs additional clarification. So the conversation that you're having today is a very good, worthwhile conversation to have about mandatory reporting and what is or is not occurring in the school setting. So with that, in preparation after the subcommittee meeting last week, I knew that it would probably be good to have an actual practitioner here today. And so Jennifer Diaz with Gwinnett County Public Schools is here. She's also on the board for the Georgia School Counselors Association and is a practicing school counselor. So I want her to share just for a few minutes about the importance of this to hopefully clarify why we would want to see a piece of legislation like this and to help you understand the position that school counselors are in when a situation like this occurs. So Jennifer.
Yeah.
Jennifer Diaz.
Thank you. This is inspiring. You're actually really talking about my job, everything I do every day. We're not always aware that that really happens. So I'm at White Oak Elementary School. We have 750 students. I'm the only school counselor there. And the word that is floating through my head that y'all keep not knowing is designated reporter. At each school there is a policy for reporting abuse, and usually there is a designated reporter in the building. I am the designated reporter for my school. Certainly in Gwinnett County schools, the counselors are the designated reporters. If I am absent, not there, the next person is one of the administrators, our assistant principals or our principal. You know, the questions come up of, do we need to know? Well, we certainly need to know whether or not they've received our report because our job is on the line. We have to report that, and if we don't report it, we can lose our job. So we need to know that they got our report. There have been many times before the new changes that I have faxed in a report, and I don't know whether or not they received it. My fax machine tells me that they received it, but did it fall onto the floor? What did they do with that? So that information is really helpful for us to know that we can stop calling them and we can stop bothering them about this particular case. Whether or not the case, the information about the closing of the case, whether it was substantiated or not, is very important to me personally. Again, like you had, I can't remember your name, Representative Sharpton. It is educational to know whether or not something I felt had happened or not. But really, I think what's more important, too, is to know that we're trying to help these kids and we're trying to help their families. And when we're in the trenches with them, so to speak, we need to know what are the next steps we need to take to be able to help those families and those children. If I make this report to DFACS and they feel like nothing has happened and I know that the case is closed, then I know if something else comes up, I need to make another report. Oftentimes, we make our reports and then our hands, we're out of it. We don't know because they don't share that information with us. I had a case recently where I made a report about a child that was being neglected and abused, and the case was turned over to a counseling agency, and the case was closed. The counselor that was assigned to the family didn't know that the case was closed until she and I spoke about what was going on with the child. She said, well, I'm going to call the caseworker because I think, something's going on. And when she called the caseworker, she found out that the case was closed. I immediately turned around and made another report to DFACS because this child needed help. After that report, the next day the child was taken from the home because DFACS said, you're right, there are some things going on in this family with this child. So this bill would really help us to know what the next steps are and how we can help our children. And it's not that I want to know the dirty details. I really don't. I probably already know the dirty details. But them letting us know, yes, we've substantiated this, that this is confirmed, this has happened, will help us in the future with the next steps with the children. So.
Thank you. Any questions? Representative Welch.
Ms. Diaz, the code section that we're looking to amend already currently has a provision for any adult who makes a report of child abuse. This we're creating a new carve out, and this would be a subparagraph to it. Now we're seeming to do this in particular for school teachers, school administrators, school counselors, etc. Why would we not just revise the existing paragraph 5 so that anyone who is a mandatory reporter under 19-7-5, why wouldn't we allow them all the same privilege, to obtain that information and know that they've actually made the report's been acknowledged? Mm-hmm. Why wouldn't we do that for all of them? Why are we carving out specifically this mechanism for just the school teachers, school administrators, and school counselors? Do you know?
Well, I can't give I don't really know the full answer to that question. I can tell you as a school personnel, and in my years of experience as a school counselor, we're the ones that make the majority of the reports. When the DFACS goes to the families usually pretty able to figure out that it was us. Certainly there are other people in the community and coaches, they make those reports as well. And I can tell you that they would deserve to know whether or not that report was made as well. Certainly would have concerns about a community coach having information about whether or not the report was substantiated or not. But again, that's good information for us to know. And especially as a school counselor, if I am the one making the report and I'm working with that child throughout the rest of the year, to have that history and to know what's happened with the family. So in terms of other folks, I'm not quite sure I can answer that question.
And then as a follow-up, the language of the bill has other school personnel, but looking at the current law that deals with mandatory reportings, other school personnel is not included in that list. So there's a specific list of mandatory reporters. Teachers, administrators, and school counselors are all on that list. Other school personnel is not. And so I think that Representative Atwood has a legitimate concern there that we would actually be creating, in a sense, at least a confusion in the law where we would have someone who's entitled to a report, but they're not mandatory reporters. So I think we're creating some confusion right there in the law if we leave that language in there. I don't know if you had any thoughts on that or if there was some other reason. Well, no. My understanding of the law is that if you work with children, you're a mandated reporter. So that includes everybody that works in the school, anybody that works with children. Certainly there's always language in laws that can be confusing to folks, but I know that one loud and clear. If you work with children, you're a mandated reporter.
Chair has a question. Mr. Diaz, I think you heard the conversation concerning there's a provision in the bill that says other, let me look at it says other school personnel. And I know you probably don't have a copy of it. Let me see.
I have a copy of some revisions at some point.
I'll get you a copy of it.
Okay.
And the lines are numbered, so I'm going to bring your attention to that.
Okay. Thank you.
In line 14,
yes, sir.
It says counselor, comma, or other school personnel, comma. When you see other school personnel, and it also says, I guess you need to see line 13 up there too. It says teacher, administrator, counselor. What does other school personnel mean to you?
Well, like you said, it could certainly be the janitor because that's a school personnel. But my first thought, like Representative Chandler said, really is the school psychologist that I work very closely with and school social worker as well. We would be the main people that would make that determination.
Okay. And I understand that there's a protocol from Ms. Chandler, or as Representative Chandler said, that every school has a protocol for child abuse and reporting it.
Yes.
That other school personnel is going to come to you, correct?
Correct.
If not you, the social worker or the psychologist, correct?
Well, correct. At our school, it's our administrators would be the second line, right. But the people that would have a reason to make a report without having it come from a teacher would be the school psychologist or the school social worker.
Okay. Okay. Thank you. Any other questions for Ms. Diaz? Ms. Diaz, thank you very much.
Thank you.
And I'm glad you could see we actually try to consider what you guys are doing. Josh Stevens, Professional Association of Georgia Educators.
Yes, thank you, Mr. Chairman and members of the committee. I'll be brief. Professional Association Georgia Educators represents over 85,000 educators throughout the state, and we're always pleased with any efforts to ensure the safety of students. And our educators, in this instance, always take their duty to report suspected cases of abuse and neglect very seriously. And we appreciate this HB 914 that will give educators better confirmation that their reports have been received and are being handled by the services. So we just wanted to offer our support for the bill.
Okay, yeah. That's it. That's exactly right. Exactly. Thank you, sir. Any questions for Mr. Stevens? Okay. All right. Well, the committee will be at rest for just a few minutes, about 5 minutes. I guess we'll just take a break for 5 minutes. Call this meeting back to order. Okay, Jill, you gonna read this to us? Since you got it? Okay. I want to propose a committee substitute for the bill, and we probably need to hear a little comment on this. If I could ask the attorney for Juvenile Justice Committee to read back the substitute, and I believe we have supported the author on this. Is that correct, Mr. Wilkerson?
Yes, you did.
Okay. If you could, Ms. Taylor, well, I want to call you Chandler.
Something along the lines of any adult employed by a school and required by Code Section 19-7-5 to report suspected child abuse shall be notified in writing by the department or governmental child protective agency that such report was received within 24 hours of the receipt of the report by the department or the governmental child protective agency, which I think can be said a little tiny bit more succinctly when I have the computer language in front of me, but words to that effect. And then the second part is, within 5 days of the completion of the investigation regarding the reported child abuse, the department or governmental child protective agency shall submit in writing a report as to whether the reported child abuse was confirmed or unconfirmed to a school counselor for the school that such child was attending at the time of the report, and when there is not a school counselor, to the principal for such school.
Any questions on that substitute?
Is it possible to get that last part right? It did say upon completion of the investigation, right?
Within 5 days of completing the investigation.
Okay. And then the second piece was, is it possible to make that 5 business days instead of 5 days, or does that?
How about
Five
just,
days,
let's
okay.
leave it at 5 days.
5 days.
That way.
Okay. Okay.
We need something, a deadline on that.
Okay.
Is there somebody here from the department? Come on up. Could you mind stepping up to the witness stand? Thank you. And you're Ms. Fielding?
Yes, sir. My name is Ashley Fielding. With the Office of Legislative Affairs and Communications with the Department of Human Services.
Were you able to hear that and get a grasp on what we're trying to do?
Yes, from what I understand, y'all would like us to respond within 24 hours to all mandated reporters.
Confirming receipt of the report.
Yes, sir. And then to school personnel, we would then follow up at the completion of an investigation.
Then you would follow up at the completion within 5 days of completion of the investigation with the school counselor. And if they don't have a school counselor, then the principal of the school.
Yes, sir.
Is that language is that parameters you think you can work within?
We are comfortable with those parameters. I do want to be clear that the initial notification, would that be that the department send that notification within 24 hours, or is the, okay.
Yes.
Then we are comfortable with it, yes, sir.
Okay. Is there any other comment you have on the legislation? I didn't mean to leave you out. I really, I just didn't see you over there behind the
No, that's
column.
perfectly okay. Representative Wilkerson has been great about contacting us and making sure we're aware. Some of this is actually already department policy. However, what we found is that that policy has been carried out in different ways across the state. So this is something that the department is very supportive of.
Okay, good. Thank you very much. Okay. Any other comment from you guys? Okay, now's a good time to comment. Okay. Okay. No further comment of the committee and no further comment from the public. Do I hear a motion? Unless y'all want to stay here a little longer. I have a motion to pass. As a committee, is that the committee substitute, Representative? Okay. Motion do pass at the committee. It's LC 371748S by committee substitute. And I have a second. Any further comment? All those in favor of the motion to do pass of the committee substitute as stated, signify by saying aye. Aye. All opposed, no. Passes unanimously. All right. Thank you very much, ladies and gentlemen of the committee.
Thank you.